A very warm welcome to everybody. Let me share my screen. I am hesitant to call myself Dr. Donnelly in this context, being, of course, in no way, shape, or form a medical doctor. But be that as it may, thank you so much for the introduction. Today, I will be talking about artificial intelligence in healthcare from a legal perspective, looking at the legal and regulatory framework. And because of our short time, it will be pitched at a very much an introductory level, but I hope it will spark much discussion. So as we look at the concept of AI, for many people, it is viewed as the future of healthcare in South Africa. The capacity of AI systems to operate, at least to some degree, autonomously from the human healthcare practitioner, and to use machine learning to generate new, often unforeseen analysis and predictions is what sets the AI system and AI-powered medical robots apart from all other forms of advanced medical technology. And so it's a key priority for us to develop laws and policies to support the ethical and transparent use of these technologies and the development of health data sets on which algorithmic models can be built. The focus of today's presentation is on clinician-orientated AI, in other words, patient interactions that are directly mediated by a human healthcare practitioner assisted by AI. But there are other applications for AI in healthcare that are virtually endless, including health wearables and health apps, service and administrative orientated AI, including digitized health records, and of course, AI-powered medical robots with increasing degrees of autonomous decision-making powers. So to begin, I'd like to look at some of the key policy issues. The need for regulation is, of course, especially high in a high-risk area such as healthcare. Where developing trusted AI technologies promises many benefits to address the lack of access to healthcare facilities, a shortage of skilled healthcare practitioners, and it could lead to great advances in healthcare through better prediction, prevention, diagnosis, and treatment of disease. But there are barriers, technical, regulatory, and ethical concerns, and lack of access to robust open data sets, which are holding AI back, particularly in Africa. And at an international level, the development of specific laws to regulate AI remains in its infancy. The Council of Europe has an ad hoc committee on AI that is putting forward a proposal for an AI treaty that remains at a feasibility or scoping stage. And so what we do have at this stage are guiding normative principles or policy statements that are largely convergent, and many different versions have been issued by international organizations and corporates. And they encapsulate values that are well set out in the OECD's 5 principles on AI, which was published in 2019. And it emphasizes beneficence, in other words, develop AI to benefit people and the planet. It emphasizes respect for human rights and freedoms. And this means that appropriate safeguards do need to be in place to enable human intervention where necessary. And that's particularly important, I think, in the healthcare context. It emphasizes the concept of transparency and fairness. And primarily this becomes an issue around how we make responsible disclosures to patients in a healthcare setting or research participants about how the technology will function in a way that can be understood by them and challenged by them when it operates unfairly. Fourth, it emphasizes security, which is a broad concept requiring us to develop technology that can function in a robust, secure, and safe way. And in a medical context, again, it's particularly important to understand that this is throughout the life cycle of the product and requires that potential risks are continually assessed and managed. And lastly, emphasizes accountability of the organizations and individuals developing and deploying AI systems to ensure that they operate in accordance with all of these principles. Now, in South Africa, we don't have a comprehensive AI policy. We don't have any specific laws dealing with AI, but we are a member of the G20. And so the G20 AI principles are in turn modeled on the OECD principles that I've just mentioned. They in turn strongly overlap with the EU framework for trustworthy AI, work being done by UNESCO, and various institutional commitments such as that by Google and DeepMind. In their report, the Presidential Fourth Industrial Revolution Commission did emphasize, although they dealt with the topic briefly, the importance of ethical and transparent use of these new technologies. And of course, public health policy emphasizes improved access to healthcare and improved patient outcomes as key policy goals. So in fact, I would add that to the extent to which South Africa's current legal and regulatory environment inhibits the uptake of responsibly developed AI, those laws and guidelines are directly at odds with national policy imperatives. However, how these soft principles, these ethical guidelines are to be interpreted, and the extent to which they will actually be applied is debatable. And so we do need to develop laws. My presentation will touch briefly on 4 topics today: restrictions in the current policy and regulatory framework, implications for informed consent, legal liability, and the issue of autonomous processing of health data. First, of course, we need to try and define artificial intelligence. There is no categorical definition. Up on the screen, I'm showing you the definition offered by the European Parliament resolution from October 2020, recommending a framework of ethical aspects of artificial intelligence, robotics, and related technologies. So you'll see from that definition that AI could be software-based or embedded in hardware devices, but it displays intelligent behavior and it operates with some degree of autonomy. And there's a similar definition that has been put forward by the OECD, which again indicates that AI is intelligent. It makes predictions, recommendations, or decisions. So if we look at the regulatory framework, the first aspect I want to touch on is the role of AHPRA, the Medicines and Related Substances Act. Of course, AI applications developed for use in South Africa will have to comply with a range of national statutes, the National Health Act, Health Professions Act, the Medicines and Related Substances Act, amongst others, and alongside consumer regulation and privacy regulations. But if we look at this act in particular, we need to consider the role of software or AI software as a medical device and whether that is adequately regulated currently in South Africa. So up on the screen is the definition in the Act that a medical device includes any machine and software intended by the manufacturer for use in the diagnosis, treatment, monitoring, or alleviation of any disease or injury and the prevention of any disease. So many possible applications of AI in the field of healthcare will fall within this definition. But there are some blurred lines. 2 examples causing discussion in the area are health chatbots and the distinction between providing information versus a technology that's intended by the manufacturer to, in fact, diagnose or provide medical advice. The other problem area or blurred line is, of course, smart wearable devices and health apps. And this blurs the line between medical devices intended for self-monitoring by the patient and unregulated lifestyle or general wellness products. So what is the problem? Well, the current framework requires medical devices to meet defined standards of quality and to be registered with AHPRA. They are registered after they've been evaluated and assessed, and obviously the sale of any unregistered medical device is prohibited. The provisions, primarily Section 15 of the Medicines and Related Substances Act, require AHPRA to receive particulars and, where practicable, samples of the medical device before they can evaluate and approve it. So this is essentially a single stage model of regulatory review according to predefined static specifications and standards. But AI systems are adaptive. And I'd like to explain that a little further. I'm mindful of time with some examples in a healthcare context, because some of the terminology might be unfamiliar to those of you here today. When we talk about AI being adaptive, we mean that, well, let's take a step back. AI is using what we would term big data analytics, and it's powered by complex algorithms that collect and interpret data. So an algorithm is simply a computational process or a set of coded instructions that will be implemented by the computer program to perform a function or solve a problem. But in AI, new machine learning or ML techniques enable AI to complete its tasks in a way that mimics human intelligence, because the machine can move beyond a coded set of instructions, and it can adapt and improve as it learns from the data. But what that also means is that this deep learning by the machine that is powered by adaptive algorithms means that how the machine will respond to and interpret data is no longer predetermined or entirely predictable. So, for example, if we look at robots as the future in medicine, you would distinguish between deterministic robots that can act autonomously but only in accordance with pre-programmed instructions, and robots that have some degree of cognition. Powered by adaptive algorithms, they can respond adaptively to their environment. So what is the solution? Well, one possible solution is to develop a new total product, sorry for the typo there, product life cycle regulatory oversight mechanism. It's being explored currently in the US by the Food and Drug Administration, and there are other developments that I cannot go into in detail today underway in Europe and within the International Focus Group on AI for Healthcare. The next problem area or stumbling block for adopting AI is the role of the Health Professions Council's ethical guidelines for healthcare practitioners, which remain rooted in the frankly outdated era of telemedicine. So up on the screen is the definition from the guidelines of telemedicine, and it's the practice of medicine using electronic communication and information technology or other electronic means between a healthcare practitioner in one location and a healthcare practitioner in another location for the purpose of facilitating, improving, or enhancing clinical, educational, and scientific healthcare and research. Now, there have been extensions to the definition recently, which I don't intend to discuss, as those are related to our response to the COVID-19 pandemic, and they're intended to be temporary. So if we stick with the current definition of telemedicine, what is the problem? Well, the problem is that telemedicine still requires that in every case there must be a face-to-face examination, a consultation and physical examination of the patient in a clinical setting by a human healthcare practitioner. So is there any solution to this? I mean, in many instances that won't pose a problem. As I mentioned earlier, there are many applications of AI where the technology will be assisting a human healthcare practitioner, and the requirement of a face-to-face physical examination will present no problems. But it does limit potentially wider applications of AI. And it raises a particularly interesting legal problem, which is that while our law recognizes juristic persons like companies It does not presently afford any legal status to things. So there'd need to be a radical reimagining in our law if we were to address the new risks and roles for AI. And I've suggested on the screen that lawmakers and regulators will need to start asking tricky questions. Can AI act as a servicing medical practitioner and replace the human practitioner who might have been performing the examination in the old telemedicine context? Can AI provide advice without direct human intervention? And by that, I don't mean without any human oversight. As we saw in the OECD principles, human oversight and the ability to intervene when necessary is important, but I mean without being directly mediated in the clinical setting. And so these questions remain unanswered. The next issue is informed consent. And of course, in addition to obtaining the patient's informed consent to issuing any prescription and any course of treatment, the patient must also consent to the use of technology. And the National Health Act requires that every healthcare provider takes all reasonable steps to obtain the user's informed consent. So they state that the user is to have full knowledge, and this requires that they are informed of the range of diagnostic procedures and treatments generally available, and the benefits, risks, costs, and consequences associated therewith, as well as any implications of refusing treatment. So they also add that where possible, the explanation must be given in a language and in a manner that the patient can understand. And I would suggest that in some respects, that's a paradox. If the patient does not understand, then the consent is not informed. So this creates a problem when we are dealing with complex technologies like AI, and there's currently intense scholarly debate taking place around the legal requirement for transparency or explainability. In my view, when it comes to practical implementation, we will need to be pragmatic. In the case law on informed consent, it has already been held that unduly detailed explanations of complex medical procedures are not required. In fact, they're more likely to confuse rather than inform the patient. So if we apply that to the AI context, I would say that an unduly technical explanation of the computing processes underlying the AI system would also be counterproductive and not required. Instead, I would propose that informed consent to the use of AI technology in a medical context requires us to focus on the need for the patient to understand enough about the risks involved in the process to make an informed decision about whether to proceed. And that brings me to probably the most difficult legal question, which is, what happens when things go wrong, and particularly when the machine makes a mistake? And here I mean a mistake that could not be anticipated. So common law imposes fault-based liability on the human healthcare practitioner. In very simple terms, the doctor can be held liable if they fail to meet the standard, objectively measured, that is expected of a reasonable practitioner in their branch of the profession. But AI raises the explainability problem, or what is referred to as the black box algorithm, where the inputs and the outputs in the form of the machine's diagnosis are known, but the inner logic by which the machine reached those conclusions is inscrutable. And that makes it virtually impossible, even for the developers of the technology, to explain in all cases why a particular result was reached or why a mistake was made. So the latest EU legislative proposal on civil liability classifies healthcare as a high-risk use case for AI, and generally proposes strict liability that would be imposed jointly and severally on the developers, on the operators of AI systems. Strict liability, as opposed to fault-based liability, would not require the proof of negligence. And as such, if that kind of proposal were to be accepted in the EU and similarly adopted in South Africa, it would likely also come with a mandatory requirement for professional indemnity insurance against such liability. Lastly, and very quickly, because it's not the focus of today's presentation, but is inevitably involved when one is talking about AI, you should remind yourself that from the 1st of July, the Protection of Personal Information Act came into force, and every person processing personal information is a responsible party. Health data is, of course, special personal information regulated from Section 26 onwards in the Act. And to process special personal information, you should have consent or some other legitimate ground of processing. In the context of health data, that alternative basis is found in Section 32(1)(a) of the Act, which says that medical professionals or healthcare institutions, facilities and social services can process health data if it is necessary for the proper treatment and care of the patient, or for the administration of the institution or practice. Whether that specific ground applies to all AI applications is debatable, and so that raises the difficult question of how consent can be obtained when it's required. There's two other principles from data protection law that I think might become particularly difficult to apply in relation to AI. The first is minimality, or as it's expressed in our Act, the principle that you should only process data that is adequate, relevant, and not excessive for the purpose. So this has been expressed around the world differently, but basically boils down to collecting the minimum amount of data fit for purpose. And that stands at odds with the inclination of tech developers to collect as much data as they can. And in an AI context, with the imperative that the more data we can use to train the algorithm, the better it will perform. And so we're likely to see many developments around the use of anonymization techniques to develop anonymized or even synthetic data sets. Reasonableness, I think, is also going to be problematic in an AI context, because reasonableness, as I mentioned earlier, is an objective standard based on a person. What would the reasonable person do? Or what would the reasonable doctor in your branch of the profession do? And if we think about AI taking decisions autonomously, and obviously doing so clearly by processing the patient's personal health data, that raises questions around how we interpret and apply this requirement, particularly in terms of Section 71 of the AHPRA Act, which says that a data subject may not be subject to a decision that results in legal consequences for him or her, or which affects him or her to a substantial degree. And in any medical context, that's likely to be the case. If that decision is based solely on automated processing of personal information intended to provide a profile of such person. And so I don't have answers for you today, but I believe that this is another hurdle that will need to be crossed in assessing the legal compliance of AI technologies. Alongside, in closing, the perennial risk of data security, the risk of data leaks, data breaches, and of course, controlling the sharing of data, particularly when data is being transferred across borders to jurisdictions that may not have adequate data protection laws, in which case you must have a binding data transfer agreement in which the data recipient is bound to uphold data protection standards. So these are some of the difficult issues and current stumbling blocks that face us in the regulation of AI in healthcare in South Africa. I've gone a little bit over time, which I apologize for, but I do hope that I've given you some food for thought and that you have learned something from today.